The topic on which I would be discussing is sources of environmental law in India. Why the discussion on source is important. The sources would lay down the foundations, thereby casting an obligation to conserve, preserve, manage and regulate the environment in a way that could be done in a sustainable fashion. As far as the Indian situation is concerned, we could see that there are formal and informal sources, wherein formal sources refer to those which are legally recognized ones, and informal ones are referring to the efforts taken up by the communities, the non-governmental organizations and even the best efforts done by the public spirited individuals. And based on that premise, if we proceed, we could see that there are certain sources which are well evident in the Indian context. One is the Constitution of India adopted in 1950, the legislations which are enacted in accordance with the provisions of the Constitution, the decisions of the courts, particularly those of the High Court and the Supreme Court, and generally the international obligations taken up by India in pursuance of the obligations laid down in the treaties. Now, to begin with, therefore, we look at the Constitution of India in the first place. We could see that if we look at the Constituent Assembly debates, there were discussions centered around fisheries and forests particularly, or the issues like health and sanitation, discussed at length as to where these could be allocated. The Ministry of Agriculture had actually proposed for their inclusion in the concurrent list, because the ministry felt that the agricultural prosperity of India to a large extent would be decided by the way we use the forests. So, if we leave it alone to the discretion of the provinces, it may be to the detrimental interests of the country's growth. But then there were powerful voices heard from the state provinces or the states, and therefore, eventually that could not be accommodated so. Similarly, in the case of health and sanitation, these were the measures again proposed to be placed in the concurrent list, where the union could therefore have more powers, but eventually that also was subject to pressures by the states. So, we could see that within the Constituent Assembly, for economic reasons, fisheries, forests, etc., could be have been demanded by the states to be exclusively within their purview of lawmaking. Now, moving into the constitutional scheme which has been entered into in 1950, you could see that the distribution of legislative powers discussed in Article 246 form the crux of the discussion on the matter, because Article 246 distributes the legislative powers in between the center and the states in such a way that the federal status of the country could be kept intact. But in all situations, if one looks at the language of Article 246, it gives a primacy to the union or the parliament for that matter eventually. But all out you can see that the lists are enumerated. The items for legislation are enacted in the 3 lists which appear in the 7th schedule of the Constitution. List 1 stands for the matters on which the parliament would enact the laws. List 2 for the state to enact laws, and list 3 is the one which is called concurrent list, where both the union and the states have the power to enact laws. So, the source of power is derived from Article 246 in terms of making the law, but the items are enumerated in the 3 lists in the 7th schedule of the Constitution. So, accordingly, a perusal of these entries in the list in the 7th schedule show that there are many items which have repercussions on conservation of environment and development also, but then it could be seen that it was not as seriously discussed as it is discussed in today's context. but the fact remains that many of the items which one can see in the 3 lists would have serious consequences for the environment regulation. Now, there are some situations envisaged in the Constitution wherein even though the power of primacy is vested with the Union and the state lists are exclusively reserved for the states, the Union could enact laws on state lists in exceptional circumstances. And one such article which has been used at times to conserve issues of environmental concern is the one referred to in Article 252 of the Constitution, wherein if 2 or more states make a request to that effect and the respective proposal is passed in their houses of the legislature, then the Parliament could take the initiative of enacting the legislations. Now, after the 42nd Amendment in 1976, we have added Article 48A in the Constitution in Part 4 that deals with the directive principles of state policy. Now, it therefore casts a duty on the state to preserve and protect the environment, forests, wildlife, etc. Similarly, a newly added provision in fundamental duties, Article 51AG, also casts a similar obligation on the citizens in general and also on the state. Apart from all these provisions, one can see that under Article 253 of the Constitution, it is the Parliament which has been given the power to enact laws in order to comply with the obligations undertaken by India under international law. So, one can see that even though the items may be falling within the state list, by the way the language is being used in Article 253, the Parliament is having the power to enact laws even on the state items if there is an international treaty governing the matter. Now, so generally if one looks at the Constitution of India, it can be seen that Article 246 limits the legislative powers of the Union and the states. Then there is a residuary power which in the Indian context is vested with the Parliament under Article 248. There are exceptional circumstances wherein this Union could legislate even on the state list. An example of that is Article 252. For complying with international obligations, Article 253 vests the powers with the Parliament. So, all in all, it shows that there are powers enumerated in the Constitution which could be adequate enough to protect the environment of India in a sustainable way. Now, we then move to the second source, that is the legislations enacted by the states and the Union. Now, for our purpose, we would focus only on the Union laws. This is in no way diminishing or diluting the effect of the state legislatures in their effort to protect environment. There are many states which have enacted strong legislations for preservation and management of natural resources, having a deeper impact on environment. For our purpose, we look at a few legislations. So, the list is not an exhaustive one. It just gives a introduces us to some of the legislations and their key features. So, for that purpose, I would be looking at the Wildlife Protection Act of 1972, the Water Act of 1974, the Air Act of 1981, the Environment Protection Act of 1986, the Biological Diversity Act of 2002, and the National Green Tribunal Act of 2010. Now, look at the Wildlife Protection Act of 1972. Now, it is not that we did not have the laws dealing with wildlife or regulating wildlife. We could come across some of the colonial legislations like the Wild Birds Protection Act of 1887 and Wild Birds and Animals Protection Act of 1912. Now, one could also see that these colonial legislations were enacted for certain vested reasons, may not be to suit the demands for conservation of those resources or for protection of environment for that matter. But in 1972, post-independence India had enacted the Wildlife Protection Act by making use of the provision under Article 252 of the Constitution. Now, what is envisaged in the 1972 legislation is for setting up of national parks and sanctuaries to protect wildlife and propagation of wildlife. It also later on started regulating and at times prohibiting national and international trade in wildlife. But much was desired, and therefore amendments were brought into the legislation in 1993, 2002 and 2006. In 2013, a bill is prepared which has been introduced in the Rajya Sabha. It is called Wildlife Protection Amendment Bill of 2013, wherein there was a suggestion to include a separate chapter on India's international obligations. There is a convention on international trade in endangered species of flora and fauna. Now, this convention is the one to which India is a party, and therefore, there was the suggestion made by the committee set up for that purpose to include the CITES obligations. That CITES stands for the Convention on International Trade in Endangered Species, adopted in 1973. The CITES obligations are now appearing in the bill of 2013 in the form of chapter 5B. In the meanwhile, the Ministry of Environment also has come up with a manual on wildlife to help the enforcement personnel to stringently implement the Wildlife Protection Act provisions. This was in the year 2007. Now, the purpose is to see that one of the major deficiencies of which has come across at the time of implementation was that the enforcement personnel were not at times familiar with the way the act could be used. So, in order to identify the species or the animals, birds, etc., particularly the species varieties, the manual gives even the photographs, so that the enforcement personnel could take necessary action accordingly when there is activities of illegal wildlife trade. Now, moving to the Water Act. The Water Act was enacted in the 70s to prevent and control pollution caused to the water bodies. Now, one can see a definition of pollution provided in the Act itself, which suggests quite a detailed definition in terms of contamination of water or the presence of certain substances whereby that would be harmful or injurious to the health of the human beings or to animals, carrying out of certain domestic, commercial, industrial or agricultural activities which could also be threatening the life and health of animals or plants or of aquatic organisms. So, there is a detailed definition being provided in the Act itself. Now, under the Act also, in order to control pollution, the central pollution control boards and the state pollution control boards been envisaged, and they have been constituted, which are having been vested with certain functions and powers, which would also go to the extent of inspecting the polluting units at times and sending the reports, sending the samples to the labs, and at times to take necessary action in order to control pollution. Now, pollution of water bodies like streams are considered as offences under the criminal law, and accordingly penalty is been suggested. There is a separate portion dealing with offences by companies and government departments. So, one can see that the Water Act also will take the criminal law route to see the regulation of pollution. So, accordingly the penalties and offences are characterized. Now, the next one is the Air Act, which also emphasizes on control of pollution, but here the emphasis is on prevention and control of air pollution. And therefore, it defines an air pollutant, what amounts to an air pollutant, and the definition says any solid, liquid or gaseous substance including noise present in the atmosphere in such concentrations as may be or tend to be injurious to human beings or other living creatures or plants or property or environment. One can see that it involves all substances which could contribute to air pollution, including noise. So, what amounts to a noise pollution, there are separate rules which are provided under the Act. Now, again there is a pollution control boards which have been vested with the powers, and at times the pollution control boards could actually apply to the court to restrain certain activities. And the state government has the power to declare air pollution control areas, and there are examples like in the case of West Bengal, the whole of West Bengal has been declared as an air pollution control area. Like the Water Act, the Air Act also deals with offences by companies and government departments, and to that extent criminal law of the country is being used. Now, there is an umbrella legislation which has been brought into effect in 1986. This was in the aftermath of the Bhopal gas leak disaster. Now, this is a legislation which is covering environment in general for the whole of India, and accordingly they define environment as including water, air, land and the interrelationship which exists among and between water, air and land and human beings, other living creatures, plants, microorganisms and property. So, a holistic definition of meaning of environment is provided under the Environment Protection Act, and this act also brings in a number of rules, regulations and notifications in the form of delegated legislation. So, we can see the Environment Protection Rules of 1986, the Hazardous Waste Management and Handling Rules of 1989, notifications like the Environment Impact Assessment, the EIA is one which is required specifically for any development projects. Now, what amounts to having given a meaning of environment, it also defines on environment pollutant. What is polluting the environment? As any solid, liquid or gaseous substance present in such concentrations as may be or tend to be injurious to environment. It also gives a meaning to hazardous substance, that is any substance or preparation which by reason of its chemical or physical or chemical properties or handling is liable to cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. Now, the powers of regulating the environment for that matter is vested with the central government, and a complaint could be brought in by the central government or any authority or person authorized in that behalf, and in exceptional situations even individuals could bring in complaint. Now, this act also deals with, like the Air Act and Water Act, offences by companies and government departments are dealt with separately. Now, in the year 1991, a Public Liability Insurance Act was brought in. These all are acts after Bhopal gas leak, and which was envisaged to give immediate relief to victims of an accident arising from handling hazardous substances. Now, here the liability is fixed on the owner based on no fault basis. So, there is no requirement of fault in order to fix the liability. Now, it imposes a duty on the owner to contribute to the relief fund to take up insurance policies accordingly. Now, what is termed as an accident, in order to invite liability of the owner on no fault basis, is that which involves a fortuitous, sudden or unintentional occurrence while handling any hazardous substance, resulting in a continuous, intermittent or repeated exposure to death of or injury to any person or damage to any property. However, the accidents involving hazardous substances occurring due to a war or radioactivity are excluded from the scope of Public Liability Insurance Act. Now, there is also the roles being envisaged for the state government and state pollution control boards. Again, under this act, offences by companies and government departments are dealt with separately. So, a perusal of the acts like Air Act, Water Act and Environment Protection Act along with the Public Liability Insurance Act shows that the criminal law mechanism is being used in order to tackle the violations. Now, in 2002, India has enacted the Biological Diversity Act. This was in order to comply with the obligations of India under the Convention on Biological Diversity concluded by the UN in the year 1992. Now, India is a country with a rich reservoir of biological resources, and access to these biological resources for research purposes and for commercial utilization is a long pending demand which involves foreign partners or institutions. So, what the Biological Diversity Act looks at is regulating the biological resources access by categorizing the people who are using it in accordance with the involvement of, by looking at the element of foreign participation. So, the first category under this legislation needs a prior approval of the National Biodiversity Authority if the use of these resources are for research, commercial utilization or biosurvey and bioutilization. In category 2, it needs an approval, it shall give, it is not an approval, it needs a prior intimation to be given to the state biodiversity boards, and this is for those categories of people like the citizens of India, any body, corporate or undertaking or organization registered in India, thereby showing that it is not having a foreign involvement in it. Now, there are exemptions from this approval or regulatory process provided to people or local communities of the area, the growers and cultivators of biodiversity and the practitioners of indigenous medicine. The National Biodiversity Authority is constituted under the Act, which emphasizes on regulating research, commercial utilization, etc., involving the biological resources of India. They also have the role of advisory role to be performed vis-a-vis the state governments and central governments, and take measures even to oppose the grant of IPR in any country outside India on any biological resource obtained from India or knowledge associated with that resource. Now, the Act also has provisions for constitution of state biodiversity boards, which advises the state governments on conservation and sustainable use of biological resources. There are also provisions for equal benefit sharing. If the resources and the knowledge related thereto are accessed by the researchers or the commercial users, there needs to have a mechanism of benefit sharing. Now, the Act provides for various kinds of benefit sharing, like a grant of joint ownership of the intellectual property rights to the National Biodiversity Authority or to the claimers, transfer of technology or the location of production, research and development units to be in such areas which would therefore facilitate better living standards for the claimers. Then association of Indian scientists, benefit claimers and local people in the R&D initiatives, setting up of venture capital fund for supporting the cause of benefit claimers, payment of monetary compensation and non-monetary benefit. So, there are a number of mechanisms being provided, envisaged under the Act for giving an equitable sharing of benefit to the claimants of the knowledge or those protectors of the resources. Now, in the case of monetary compensation, the money needs to be deposited with the National Biodiversity Fund. So, there is a constitution of a National Biodiversity Fund being provided in the Act. Now, in 2010, we have enacted a National Green Tribunal Act, wherein it facilitates a complaint by any person on an environment dispute or a person who wants to have compensation. So, there is a dispute settlement body which has been created exclusively relating to matters on environment and the compensation claims. Now, it has its principal office in Delhi with other places of sitting in Bhopal, Pune, Kolkata and Chennai. Now, the National Green Tribunal Act provides for the application of principles of natural justice in order to determine the cases. There is a time limit within which the disputes or claims should come before the tribunal, and the tribunal consists of judicial and judicial members and also experts working in the field of environment. Now, the tribunal decisions are subject to appeal to the Supreme Court. Now, there are apart from this the legislations which are discussed with their key features, there are a number of legislations which one may come across in the course of the discussion on protection of environment, like the Forest Act of 1927, the Forest Conservation Act of 1980, the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006, and the number of laws like the mining laws, which also have serious effect on environment. Apart from that, we do have the environment impact assessment notifications, the coastal zone regulation notifications, noise pollution regulations, hazardous substances handling rules, etc. So, the legislations on environmental law in India is incomplete without a reference to the number of notifications, rules and regulations which are being issued from time to time. Now, look at the third part of the sources discussion, that is on judicial decisions. Now, if one looks at how judiciary responded to issues of environmental concern, one could see that in the initial years it was not necessarily in the context of environment, but at times in terms of the health concerns, the adverse health concerns, the issues were taken up by the court. If one looks at the state of Rajasthan versus G. Chawla decision, one could see that the use of amplifiers was regulated and the state legislation to that effect was upheld by the court in order to see that it will not be causing detrimental effects on public health standards. We also have instances where the judiciary has used the public nuisance provisions or the criminal law provisions regulating the nuisance. Accordingly, the judicial decisions were focusing on those issues, not necessarily on environment. But with the increasing awareness about environmental protection, the courts have used the constitutional mechanisms in order to expand the scope of environment protection in this country. For instance, we can see this expansion through Article 21 of the Constitution, which gives a right to life and liberty to the people, Article 48A, which is a directive principle of state policy, and Article 51AG, which is a fundamental duty. And the means which have been used for securing this right to environment was through the writ petitions or public interest litigations in the later on years. We look at a few cases to see how the discourse on environment protection happened before the judiciary of the country. We have an earlier case of 1980, which is called Rathram Municipal Council versus Vardhi Chand, where the municipal authorities were put to task by the court when there were no cleanup of the sewage systems. In 1987, one of the major decisions came from the court in McMehta versus Union of India, where the court had for the first time laid down the rule of absolute liability, fixing a liability in absolute terms without any exception. So, we moved from the rule of strict liability, which is used in tortious claims, to a principle of absolute liability, not recognizing any form of exception. The court said in that case that if an enterprise is engaged in a hazardous activity, is a potential threat to the people working in the factory and those living in the nearby areas, the owner of the enterprise should be absolutely liable. This case is otherwise known as the Oleum gas leak case. Similarly, in 1986, the Rural Litigation and Entitlement Kendra versus State of UP, the court said it is for the government to decide in each case that to what extent exploitation of mineral deposits be permitted at the cost of ecology based on appropriate evidence. In that context, the court also said that the task of environment protection is not only the task of government, but also of every citizen under Article 51(a)(g) of the Constitution, because it is a fundamental duty which is the one which is casting obligation on the citizens in general. This was again a case of illegal mining in the Mussoorie Hills. So, the court said that it is for the government to decide how exploitation of minerals could be permitted without compromising the ecological balance. Again in 1987, the court was dealing with the tanneries discharging effluents into in the Kanpur district, and the court said the tanneries cannot function without fulfilling the minimum requirement of a primary treatment plant. So, if you do not have a mechanism to dispose of your waste, then you have no right to run a factory. In that context, the court said, just like an industry which cannot pay minimum wages cannot be permitted to continue functioning, a tannery which cannot set up a primary treatment plant cannot be allowed to function, as the adverse effects on public outweigh the loss of management and labor on its closure. Now, in McMehta versus Union of India, again in the year 1987, the court was dealing with Ganga water pollution. There again the court said that it is the duty of the central government under Article 48(a), which appears in Part 4 of the Constitution, to introduce compulsory lessons on environment protection in schools. In 1992, in another McMehta case, the court gave directions to spread awareness on environment protection through mass media, information films and educational courses. What all in all some of these judicial decisions show to us is that the protection or conservation of environment, management of natural resources do not fall exclusively within the purview of the state or obligation of the state. All of us as citizens of the country or the people residing in India do have an obligation to create awareness and protect environment accordingly. In the year 1991, the court was dealing with the Hanu Taluk Environment Protection Group versus BSES Company. This where the court was looking at the government's initiative when they are introducing public projects. The court said the government is to consider the importance of public projects for the betterment of the conditions of living of the people on the one hand, and the necessity for preservation of ecological balances, avoidance of deforestation that may be brought to its notice by various bodies of laymen and experts, and try to strike a balance in between these conflicting interests. Therefore, the court's role is limited to examine whether the government has taken all the necessary measures into account before granting license for a project or before approving of a public project. So, the court agrees that the public projects are for betterment of the life of people, but at the same time it cannot be at the cost of ecological damage. But then the court's role is limited to see whether the state has, the government has taken the necessary considerations while arriving at a decision in favor of a public project. In 1993, in Tarun Bharat Sangh versus Union of India, there was the issue brought into the notice of the court by the petitioner who was complaining about a protected forest in the Alwar district of Rajasthan being used where mining licenses were issued by the state government. Now, the court said the mining in an area which happens to be a protected forest is a non-forest activity which can be carried out by the state government only with the prior approval of the central government. And therefore, in the absence of a prior approval from the central government, use of protected forest area for mining purposes is not is contrary to law. The court went further in 1996 in Vellore Citizens Welfare Forum and said that they used the precautionary principle and polluter pays principle, which by that time were part of international discourse on environment protection, and the court said these are essential components of the principle of sustainable development. and part of environmental law of the country. So, the court acknowledged that any development needs to be sustainable, and in order to be sustainable they need to fulfill the principles of precautionary principle and polluter pays principle. And the court said these are part of the law of the country. So, therefore, we may not have a separate enactment as such, but these are falling within the environmental laws. And the court went further and said these are part of customary international law, and since there is no inconsistency with the national laws of India, these need to be incorporated into the national legal system. In 1997, dealing with S. Jagannatha case, the court disapproved of certain practices which were part of the shrimp farming technology. The court said there are enough constitutional provisions and legislations like Environment Protection Act, Water Act, Fisheries Act, Wildlife Protection Act and Forest Conservation Act all suggest that intensive and semi-intensive technologies which are used in prawn farming in these days are not permitted. And the CRZ notification, the Coastal Zone Regulation notification, is to have an overriding effect over other legislations, since that is issued under the Environment Protection Act of 1986. In the Taj Trapezium case of 1997, the court held that the industries of that particular zone using coke or coal are actually polluting industries, and therefore, these are damaging Taj as a monument, and therefore, the court suggested them to these industries to convert to natural gas or rather stop functioning and relocate themselves to any other place, but they cannot be functioning using these materials within the vicinity of Taj. In 1997, in McMehta versus Union of India, the court was brought to the notice of the falling groundwater level. The court accordingly directed the government to set up the Central Groundwater Board as the authority under the Environment Protection Act of 1986. In the Kamal case of 1997, the petitioners contested the lease of riparian land to a private company for commercial purposes on the banks of river Beas. The court held that this lease amounted to a violation of the public trust doctrine, wherein the state is the trustee of all natural resources to be used for the enjoyment of general public. So, that was one case where the court relied on the US decisions and introduced the public trust doctrine to the Indian context. Similarly, in 2001, dealing with Professor Naidu case, AP Pollution Control Board versus MV Naidu, the court said that the establishment of industries within the 10-kilometer radius of two major reservoirs of Andhra Pradesh, namely Usman Sagar and Himayat Sagar, falls within the clear prohibition, and state government cannot grant an exemption. So, the court did not approve of the projects. In 2001, dealing with the Delhi context in McMehta case, the court directed the phasing out of non-CNG buses from the roads of Delhi and fixed the time limit for the switchover to a CNG. Now, in 2004, the question about the legality of a mining activity happening in up to 5 kilometers from the Delhi Haryana border on the Haryana side of the ridge and in the Aravalli hills was raised before the court. After going through the background of the case and the previous orders, the court held that the Aravalli hill range needs to be protected at any cost. Therefore, a mining activity could be permitted only on the basis of sustainable development and on compliance of strict conditions. In 2005, in a reference noise pollution case, Supreme Court examined the implications of the noise pollution vis-a-vis Article 21 of the Constitution. The court was dealing with the case of noise pollution caused by the firecrackers, loudspeakers and vehicles in the light of the 2000 regulations on noise pollution. The court issued a direction to all the states to make provision for seizure and confiscation of loudspeakers and amplifiers and other devices which are causing noise pollution beyond the permissible levels. In the Kudankulam nuclear power plant project case, which came up before the court decided in 2013, the court said that the central government and the state government have constituted committees. The committees were satisfied with the safety and security of the plant and safeguards, and therefore, all principles of sustainable development and its impact on ecology had been taken into account before approving the project. So, to sum up the discussion on sources of environmental law in India, we can see that there are binding obligations created through the constitutional instrument, the Constitution of India. There are a number of legislations which are enacted in the subsequent years and also particularly after the Bhopal gas leak disaster. We can see that initially India dealt with environmental issues, not particularly emphasizing on environment as such, but through the criminal law mechanisms. But over the years, India has been developing specialized legislations dealing with environmental issues of different kinds. These are also supplemented by the rules, regulations and notifications from time to time. And Indian judiciary has played a pivotal role in developing environmental law for this country. This is in addition to the efforts of public spirited individuals like McMehta. One can see that the judiciary has expanded the scope of the constitutional provisions. It extensively used the specialized legislations on the subject matter, and it also tried to look at the role of the executive in the whole exercise. But at times the judiciary restrained itself by suggesting that if the matters are discussed by the government following the requisite norms, then it will not fall within the purview of the court to examine what the executive has been doing, because there is a clear demarcation of separation of powers. Therefore, the court could actually only look to the extent up to which the government has taken into account the necessary considerations before approving of projects. But overall, we can see a gradual development of environmental law discourse happening in the country and increasing awareness about environmental issues throughout the country as a whole.